good afternoon, everyone. In the interest of time, I suggest that we get started. Welcome to all those attending in person as well as remotely. So we had a panel this morning talking about charter issues and criminal procedure. This afternoon, we shift to the more substantive realm. So our panel is entitled Substantive Justice and Criminal Law. And to discuss a series of cases that were decided this year on broadly matters of substantive criminal law, Brown, Sullivan, JJ, and Bissonnette. We're fortunate to have with us for thought leaders in the field, Professor Michelle Lawrence from the Faculty of Law at the University of Victoria, Professor Terry Skolnick from the Faculty of Law, Civil Law side, University of Ottawa, Professor Lisa Dufraimont, my colleague here at Osgoode Law School, and Megan Stevens, who is a leading practitioner of criminal law, working for, at the moment, her own firm, Megan Stevens Law. So we're going to proceed in alphabetical order. Each speaker will have 12 to 15 minutes to present their piece, and then hopefully we'll have some time for questions and answer afterwards. Professor Lawrence, you want to come to the microphone?
Yes, of course. Thank you so much. I'm going to dive right in. My husband tells me that since I left legal practice and joined the academy, I lost the capacity to speak in less than 90-minute increments. So I do fear running long. Here's 33-1. By way of background, folks here will remember that in 1994, in the case of Regina and Davio, the majority of the Supreme Court of Canada recognized a complete defense in cases of extreme intoxication, where intoxication is so severe that it is akin to automatism or insanity. To allow for a conviction in these circumstances, the majority held, would violate 7 and 11D of the Charter. As we heard this morning, Davio met with swift, significant, and very impactful public opposition. That opposition was based in large part on the perception that women and children would be at increased risk of harm if perpetrators of alcohol-fueled violence could rely on an extreme intoxication defense to avoid conviction, including to charges of the general intent offense of sexual assault. Now, Parliament enacted 33(1) of the Criminal Code, the provision here, in 1995 in direct response to those concerns. Through this provision, Parliament set out to remove the new extreme intoxication defense from the reach of accused persons charged with personal violence offenses where their intoxication was self-induced. It justified the imposition of criminal responsibility in these cases on the moral blameworthiness of a voluntary intoxication, notwithstanding the majority's very clear ruling in Davio that doing so would violate the Charter. Now, not surprisingly, in the years that followed, lower courts across Canada divided on the question of the constitutionality of 33(1). Despite this, there was little appellate interest in the constitutional question. Archie Kaiser wrote that the provision appeared to have achieved constitutional status by simple operation of osmosis. It seemed, in his words, that charter arguments against 33(1) would probably be non-starters. It was not until 2021, 25 or so odd years after the enactment of 33(1) that the issue came before the Supreme Court of Canada in a trilogy of cases. Sullivan, Chan, and Brown, the court elected to decide the issue in the Brown case. So that's going to be my first focus today. Now, Brown was charged with one count of B&E, a home, and committing the indictable offense of aggravated assault, and one count of B&E of a second home and committing the indictable offense of mischief over 5,000. The two offenses occurred 1 hour apart, 4 a.m. and 5 a.m. The prior evening, while at a house party in Calgary with friends, the accused consumed a combination of alcohol and psilocybin. What followed was an episode of delirium during which the accused lacked voluntary control over his actions. There was no evidence of co-occurring mental disorder. The accused brought as a preliminary matter a charter challenge to 33(1), and the voir dire judge concluded that the provision violated the Constitution. The accused was therefore entitled to run the extreme intoxication defense at trial, and the accused did so successfully. Was found as a matter of fact by the trial judge to be suffering extreme intoxication akin to automatism, and was acquitted on both charges. Now, the issue before the court, the only issue before the court in Brown, was the constitutionality of the provision, and Cassier wrote for a unanimous bench, as we heard this morning. At the outset of his judgment, though, before turning to the legal issues, Cassier took a moment to speak about factual issues. No doubt mindful of the criticism that followed the Davio case, at the very outset of the judgment, Cassier directly addressed the question of whether, as a matter of fact, alcohol could produce extreme intoxication. And he stated, these cases are not drunkenness cases. Rather, they're cases involving the alleged use of drugs taken alone or in combination with alcohol that produces something different: psychosis, delusional, and involuntary conduct. Cassier adopted the language of the Ontario court in Sullivan to the effect that it's not even clear that extreme intoxication by alcohol can produce the mental state that is before the court as a matter of basic science. So the general bar on intoxication by way of defense to a general intent offense remains untouched. This statement seems to have provided meaningful comfort to advocates who were concerned about alcohol-fueled violence against vulnerable populations. In a media statement issued after Brown, a representative of LEAF is quoted as saying, "Drunkenness has never been and is not now a defense to sexual assault. We are pleased to see the Supreme Court clearly and specifically spell that out." I think I went too quickly on this. That's back there. Turning then to the legal issues. This here on the slide is how the Supreme Court of Canada set up the sub-issues, and they took each in turn during the decision. I'm going to just focus on 3, 4, and 5. The court ruled, firstly, in relation to Section 7, that 33(1) violates the provision because, properly interpreted, that provision allows for the conviction of accused persons in the absence of proof of minimum mens rea and actus reus requirements. So what is then the minimum mens rea requirement? The court described the minimum mens rea fault requirements protected by Section 7 as proof of penal negligence in the form of a marked departure from the standard of a reasonable person, unless, of course, the charter requires a subjective fault element. 33(1) runs afoul of this minimum because it allows for convictions in cases where there is no objective foreseeability of the onset of extreme intoxication and no objective foreseeability of harm to others. What then is the minimum actus reus requirement required by the charter? Well, it is voluntariness. Here, the court determined that 33(1) also violates Section 7 because it facilitates convictions for involuntary conduct. And in this way, Brown is an affirmation of the majority's decision in Davio, the recognition that the voluntariness requirement, is a principle of fundamental justice. In connection with 11D, the court interpreted 33(1) as permitting a form of guilt by proxy, permitting the substitution of the fault and voluntariness of intoxication for the fault and voluntariness requirement of the violent offense. In this way, 33(1) violates the presumption of innocence because it allows for convictions in cases even when there is reasonable doubt on the question of general intent and voluntariness otherwise required for conviction of the offense. In its Section 1 analysis, Cassier identified 2 distinct purposes motivating the enactment of 33(1). The first was an accountability purpose, the objective of holding offenders to account for wrongs committed while extremely intoxicated. The second was a protective purpose, the objective of protecting victims of intoxicated violence. The provision was rationally connected to each of these two purposes, but it was not minimally impairing. The Parliament had options, including the enactment of an offense for criminal intoxication or negligent intoxication. This was an option that had been identified by other courts and by scholars on multiple occasions. So it was not minimally impairing, and it was also not proportionate, given the significance of the rights that were compromised through the provision, rights the court described as sacrosanct. Now, this is sensitive. Brown was rendered on May 13th, 2012. In it, Justice Cassier went beyond just a legal analysis, though, and offered or described a possible blueprint through which Parliament could craft a constitutionally compliant way forward in the framework generally of a 33-1. And this is exactly the pathway that Parliament elected to take. And it did so very quickly. On June 17th, just 25 business days following Brown, the Minister of Justice introduced Bill C-28, seeking to repeal the old 33 and replacing it with a new one. Here's part of the new provision. What you see is that the new 33-1 is the same as the old 33-1 in that it applies to personal violence offenses where intoxication is self-induced. In those cases, though, now, pursuant to the new 1 sub B, the accused may be convicted even if they lack general intent or lack voluntariness by reason of extreme intoxication, if the ingestion of the intoxicating substances represented a marked departure from the standard of care expected of a reasonable person in those circumstances. This is, of course, the penal negligence standard, which the court found to be the minimum fault requirement in Section 7. Sub 2 includes very helpful directions as to what the court must consider when assessing penal negligence in the context of substance use here. And what you see is an obligation to look for the objective foreseeability of the risk that consumption could cause extreme intoxication and lead to harm to another. So in my outline, which is in the drop box, I tried to pull together the common law requirements of Davio and Stone and put them together with the new 33-1 to create an analytical framework for the prosecution and defense of extreme intoxication cases. And so if you look at this from the point of view of a decision-making tree, we see that the first part of the analysis, in the first part of the analysis, the trial court must consider the qualitative nature of the intoxication. Did the accused lack general intent or voluntariness? Was that the experience at the time of the offense? And if so, was that experience the product of substance use? This is an important piece because, as per Stone, we know that the default in automatism cases is to mental disorder automatism and an NCRMD outcome. Assuming extreme intoxication is proven, the second part of the analysis involves the application of 33-1. And here, if the offense involves personal violence and intoxication is self-induced, the Crown must establish, beyond a reasonable doubt, penal negligence. Just skip through. In my outline, I've identified certain legal, evidentiary, and practical issues that I see on the horizon for these cases, and they're listed here. Just want to pause to note number 2 and number 4. The old case law was confusing as to whether the extreme intoxication defense was available in cases of simple psychosis. Brown makes clear that toxic psychosis will continue to be dealt with under Bouchard-Lebrun, and it will result in convictions. To succeed in the extreme intoxication defense, we need to see something more. We need to see something more akin to delirium, where there is not general intent or there is not voluntariness. So counsel in these cases are going to have to be attentive to the expert evidence. I'm also very curious, as a matter of practice, how the new 33(1) is going to interact with Section 16. Interactions in criminal code provisions like these, I think, are most often felt in plea bargaining. And it can be difficult for us as researchers and as scholars to understand the impact of one on the other. But I can imagine for the Crown, they may face heightened pressure to move to a Section 16 outcome if they risk an acquittal, because 33(1) is not applicable. Just by way of conclusion, going back to the accountability purpose and the protective purpose, time will tell whether 33(1) results in more convictions. If Parliament was really concerned about convictions, they could have created a criminal intoxication offense, and they didn't. They chose a political path forward, and we'll see with time. We'll see with time if that was the right call. But more importantly for me, taking off my lawyer hat and putting on my criminologist hat, is this protective purpose. Will the new 33(1) actually result in a decrease? Will it in incidents of intoxicated offending in this country? Will it contribute to greater protection for victims? And given the limited deterrent effect of the law on substance use behaviors, my expectations are modest for that impact. And as I say in my outline, and I'll say in my paper, modern understandings of the complex interplay of substance use and mental disorder suggest that greater inspiration and greater impact is likely available through a Section 16 pathway and a treatment-oriented response. So with that, I'll pass this over to my panelists. Thank you.
Professor Dufraimont.
Thank you, Francois. Can you all hear me okay? Am I speaking well? Okay, great. I'm just going to, open up my my notes. Yeah, I'll bring it a little closer, sorry. So it's just a pleasure to be with you at this conference today, and my thoughts are running all over the place, but I'm going to bring you back to a case I've been thinking about a lot, which is JJ. And it's the case that Jamie Cameron this morning decided not to say anything about it other than that it's 491 paragraphs long, which even I was amazed by that, although I've read it a couple of times. It's clearly not possible to explain this case in great detail in the time I have, or even in the number of pages that I'll be given in the Supreme Court Law Review here. So I'm going to give you a high-level summary and then get into what I think are some interesting implications of the case. So this was a charter challenge to some provisions in the criminal code that were introduced in 2018 related to evidence in sexual offense cases. Specifically, it was a charter challenge to two legislative amendments, one of which introduced what the court calls the record screening regime, a screening regime for private records that pertain to the complainant. So you may be familiar with the so-called third-party records regime. That was an idea that in the criminal code already, there was a procedure to go through to get records pertaining to a complainant from a third party that could then be useful to the defense. But the problem was, once those records, private records pertaining to the complainant, were in the hands of the defense, either through a third-party records application or in some other way, there was no admissibility control on this evidence, even though there's a serious privacy interests involved on the part of the complainant. And so there's this new private records screening regime from 2018. And then the other important thing that was challenged here was what the court calls the complainant participation provisions, which provide for complainants to participate in the evidentiary admissibility hearing that has to do with either these private records or with evidence of other sexual activity of the complainant in a sexual offense case. The sort of rape shield provisions under Section 276 now have this complainant participation aspect as well. And so that was what was at stake. The reason that the decision, or one reason the decision is so long, is that there were multiple rights claims brought under the charter here under Section 7 and 11 of the charter. But I think it's helpful to think of the charter claims as really complaining primarily about two features of the legislation. One is the amount of evidence that could be potentially excluded, right? So are we going to be potentially excluding crucial defense evidence? So there's the evidentiary exclusion problem, and then there's the procedural fairness problem. Are the procedures that have been introduced around this evidentiary hearing and this application procedurally fair? The exclusion of evidence concerns under the Charter would, of course, raise questions about the accused's right to a fair trial and right to make full answer and defense potentially being at stake if evidence was to be excluded under sections 7 and 11D is where we'd be considering that under the Charter. There was also in this connection an overbreadth claim, the thought that that too much evidence was going to be swept up into this provision and be excluded. And that was really similarly a concern about the exclusion of evidence. And then on the fairness of the procedure, the concerns here were complicated. They clustered around the requirement that the accused would have to reveal details of this evidence and the relevance of this evidence, and therefore potentially by extension, the kind of defense strategy associated with the evidence in advance of the trial. There were separate concerns about disclosure to the Crown and disclosure to the complainant. So the disclosure to the Crown was said to give rise to problems of if in advance of the Crown having made out its case to meet, the details of defense evidence and strategy have to go to the Crown. That potentially could offend the right to silence, the principle against self-incrimination, and the presumption of innocence. And then there was a separate set of concerns about disclosure to the complainant. If the complainant sees the record held by the defense before trial, that could taint the complainant's testimony. It could impair cross-examination, for example, by exposing the complainant before they testify to material that could be used to impeach the complainant. And that was said to raise those issues about fairness of the trial, the right to cross-examination, and so forth under sections 7 and 11D. So that's my quick analysis of what the claims were about, a very complex set of charter rights claims, but a really stark kind of simple division of opinion here. What we get is a majority of 6 of 9 judges written by Chief Justice Wagner and Justice Moldaver, who rejected all of the charter claims. Just none of this is valid on the one hand. And then on the other hand, you have a minority. Justice Brown really represents the dissenters here. He wrote a separate judgment, but it was separately concurred in by Justice Cote and Rowe in respect of the charter claims. And he essentially accepted all of these charter claims. So we get this, there's not a lot of nuance on it. It's all just all against the charter or all completely fine, right? So that's, there seem to be some really starkly differing views of this legislation. I am not going to go into great detail about each potential rights claim here. What I want to do is focus on what I take to be a really important theme that comes out of the majority judgment, which is the theme of judicial discretion. Because throughout the majority judgment, one finds constant emphasis on the flexibility of the regime, the discretion of the judge, the room for choice that the judge has on 2 levels. And these levels are going to, as you'll see, parallel the sort of issues that were raised here. First, on the admissibility of evidence. The record screening regime makes private records presumptively inadmissible, but it allows them to be admitted where the judge determines that the evidence is relevant and sufficiently probative. And here, this is a very clear sort of use of discretion. And it's also sort of standard in the situation where what you're concerned about is access to defense evidence. We have other areas where we have sort of discretionary rules that allow for legislation to be charter compliant because of the discretion. So you can think about the Corbett discretion, right? The Canada Evidence Act makes the accused's criminal record presumptively admissible, but there's this Corbett discretion, and it's because we have that discretion that we can say that Section 12 is charter compliant. And then we sort of see this, the other side of that in respect of the accused bringing in other sexual history evidence, and we have the history of those cases under Section 276 of Seaboyer and Derrick. And there we have the very same thing we have operating here, which is this evidence is presumptively inadmissible, but when it can be shown to be sufficiently probative and relevant, then it can be admitted. So I think it's perhaps no surprise that there's a lot of emphasis on that discretion in respect of admissibility of evidence. It may be somewhat more surprising that there's such an emphasis on the discretion around the procedural aspects of the regime, although it is also true, of course, that broadly speaking, judges in Canada are understood to have discretion to adjust trial procedures to ensure trial fairness. They have trial management powers. But this is a constant theme in the majority judgment in JJ. You get numerous examples where the majority judgment speaks to the ways in which judges are permitted to adjust the procedures if necessary to ensure fairness. So I'll just give 3 examples of what are many. So pre-trial applications under the record screening regime should be the norm. Everybody agrees on that, the majority and the dissent. But the majority says, of course, there's discretion to allow mid-trial applications, right? So if it would be unfair to insist on the pre-trial, then you can do the mid-trial. Or the application is usually going to be, that is the application with the details from the defense will usually be disclosed to the complainant before the hearing, but it can be redacted or disclosure can be withheld entirely if that's what's required for fairness in the circumstances. And the complainant is normally permitted to attend the admissibility hearing, but can be excluded from the admissibility hearing if that's what fairness requires. And so I think, and this is where maybe I go too far, but I'm just giving my editorial slant on this. So strong, it seems to me, is the theme of discretion in this judgment that I think we can plausibly read the judgment as essentially holding that exclusion of evidence under the record screening regime isn't a charter problem because the evidence, if it's important enough, we'll admit it. And fairness isn't a problem because if the procedures operate unfairly, we'll just change them, right? That seems to be what the case says, which I guess my pitch to you is that as a charter analysis, that just seems a little unsatisfying. It just doesn't seem like it's really an answer to the fairness problems that were brought forward. In a way, it seems like a way of avoiding addressing the heart of the charter issues. So just for example, one thing that defense lawyers have been very concerned about in this area is exposing complainants to potential impeachment materials in advance of testifying, in advance of cross-examination. This is described in the case by Justice Brown and by some of the lawyers as eviscerating the right to cross-examination, right? There's a real concern about cross-examination being seriously impaired by this access to impeachment materials. And I think that maybe there's some validity to that concern, but I would have liked it better if the majority had just said, it's not unfair for the complainant to have access to impeachment materials before trial. That's our judgment. It's not unfair. But instead, they said, if it's unfair, we'll change it, which doesn't seem to me to answer the question of whether it's unfair, which is what this case was really fundamentally about to begin with. So I guess that's my claim about the sort of unsatisfactory nature of the charter analysis in this case. And I guess the final thing I want to say, because I don't want to go over time, is it's not that I'm against discretion. Like I say, in the evidence area, it's totally standard that we rely on discretion even to protect legislation from becoming charter non-compliant. And on procedure, we have discretion as well. What I worry about is unbounded discretion, which is what we seem to have, especially on the procedural side of the JJ case. We get all sorts of claims about if it's necessary to exclude the complainant, we can do that. There is no discussion of in what circumstances it would be necessary as a matter of fairness to exclude the complainant. And I think it just leaves trial judges and lawyers completely at sea in trying to figure out when an explanation, when some sort of exception should be made to the procedural regime that has been upheld under JJ. So thanks very much for listening. That's my pitch on JJ.
Thank you very much, Professor Dufraimont. Megan Stevens.
Okay, I have a PowerPoint that looks like it's ready to go. Hang on. Am I right? Are you starting it back there? Am I starting it? Okay. All right, so first of all, let me start off by saying it's a real honor to be here today with these wonderful panelists and really everyone else who is here today to discuss what, at least in my small legal circles, was one of the most highly anticipated decisions out of the Supreme Court last year. And as was pointed out a couple times, maybe one of the longest as well. So the majority judgment in JJ, I think as many of you will know, has been the subject of some of the most intense criticism this last year, both as we see in the very stinging dissents that Lisa referred to, but also from the defense bar. And what I want to focus on during the time that I have today are responding to some of those specific critiques that have been leveled against this regime. And at the outset, I need to acknowledge where my thoughts are coming from on this. I have had a long-standing interest in how the Supreme Court approaches the balancing of conflicting rights in their constitutional jurisprudence. But I also, over the last couple of years, have been doing a lot of work representing complainants in precisely these types of proceedings, sexual assault cases and human trafficking cases in Ontario courts. So that will give you a bit of a bent before I even start about some of my thoughts here. So I want to pause just to note, you'll see I've included here reference to both Brown and Sullivan as well as JJ, because I think it is really interesting to note that two of the cases that we're talking about on this panel about substantive justice really took very different approaches to that question of how we balance rights when we're dealing with Section 7 and 11D claims. And I mention this primarily, I'd also note that Brown and Sullivan, everyone was on board with, we don't balance rights under Section 7. JJ, we know there's a very strong dissent, and much of that dissent, in my view, feels driven in particular by Justice Brown's concern that the Mills and Dara analytical approach to balancing rights was completely inapplicable to assessing the constitutionality of Bill C-51 and the two regimes, the record screening regime and the participation of complainants. And this, I think, also really led to objections that the majority judgment had really tipped the scales too far in favor of complainants, leading to really unprecedented restrictions on the rights of the accused. So I've just included here, you can see this later from the drive, but some of the strongly worded dissents. We do know that there has been significant criticism. I still get it on Twitter too. And so I've included here some of the comments that were circulating on Twitter after this decision was released. And, you know, there were strong words really saying this was a radical departure in how we understand constitutional, procedural, and evidentiary protections that have been established over centuries. And I also want to just highlight that bottom bullet there in relation to Justice Brown saying that Mills and Derrick approach is not appropriate because there are no other rights here that need to be considered. So really, this is what I want to talk about in kind of the rest of my presentation. Have we really completely perverted our approach to constitutional rights and charter litigation in this case? I want to start off by asking, is there any principled reason why complainants' rights should not be balanced with those of the accused in the private record screening regime and thinking about participation rights? Also, does this regime, as construed by the majority, does it really do what the critics say? Does it tip the balance too far in favor of complainants? I'm going to really focus today, because my limited time, on whether there really has been a significant expansion of complainants' rights. And then I'm hoping to have time at the end to talk about what I'm seeing on the ground in terms of some of the possible unintended consequences of this new regime. So I think the starting point when thinking about do we need to balance rights here has to be what is the trigger for these applications? When do you actually have to bring these applications? And the majority found that applications are not required for all evidence in the possession of the accused. This isn't every single thing that an accused has access to. It pertains to limited types of records. The first are what we've commonly called 276 evidence of other sexual activity. That's defined in section 276 of the Criminal Code. And then the other new change is the records that are considered private records as defined under section 278.1 of the Criminal Code. So the code defines personal information records as any form of record that contains personal information for which there is a reasonable expectation of privacy. That is then followed by an enumerated list, the kinds of records that you would think of as engaging a reasonable expectation of privacy. Therapist records, child welfare records, medical records. Those are all things that the majority says those are presumptively the types of records that will have personal information. If those are in your possession, an application is required. What was more important here was really looking at what was needed in the context of non-enumerated records. And the majority actually adopts a fairly narrow interpretation of this. And they say an application will be required if the records contain information of an intimate or highly personal nature that is integral to the complainant's overall physical, psychological, or emotional well-being. This is information that will have implications for a complainant's dignity. This is not mundane information. This is information that engages the rights of complainants. And they did reject the categorical approach. There were arguments made that any personal communications, any text messages, social media messages, those should outright not be ever considered personal information records. They rejected that and said you really need to look at both the content of the record and the context in which it was created to determine whether it is record. So we know, so the question that I have asked is there any principled reason to not have the Mills and Dara approach to balancing rights here? And Justice Brown explicitly says there's nothing to balance or reconcile. And he explains he has a variety of reasons for it. One of them is there's nothing categorically prejudicial about this information. And that follows from him rejecting the majority's narrow interpretation of private records. But when you look back at that definition, the majority did say this isn't all records. These are records that will engage privacy rights, that will engage the security and dignity interests of complainants. And when we think about the fact that a complainant will be compelled by subpoena to attend open court to testify and can be asked about this highly personal information, it's very difficult to accept that there is no state compelled action here that is engaging complainants' rights. So as you might guess, the answer is, in my view, there is no principled reason to think that the Mills and Dara approach is not applicable here. I really do think this is about assessing the fairness of trial procedures that implicate the rights of both the accused and complainants, but bearing in mind that the court has always said that the primary concern will remain the fair trial rights of the accused. So I now want to move on to what I think is the tougher question here and the other critique, which is, did the majority strike an appropriate balance? So assuming that it was right to balance rights, did they get that balance right? So that's what I want to unpack. And I want to start at the beginning, the actual application. So what is required? What does defense have to put together? It's a written application. They have to set out detailed particulars of the evidence that they're seeking to adduce or use at trial, the relevance of that evidence. We know, as Lisa said, they're typically supposed to be doing this pre-trial on 7 days notice, and that the stage 1 hearing can be in writing or happen orally. So I then want to let's look at this and compare previous regimes. Has this really been a significant expansion of complainants' rights? So we know that complainants are not entitled to receive a copy of the application at this stage. This actually stands in contrast to the third-party records regime, where an accused is required to give a copy of that application to the complainant or witness. They have to explain what records they want, why they think they're relevant to an issue at trial. And that third-party records regime, let's remember, has been in force in this country, found to be constitutional almost 25 years ago in the Supreme Court of Canada's decision in Mills. So the majority in this case, and this is what Lisa's pointed to, there's always discretion, but here they did say complainants are not to get the information. They can get a general description of the nature of the record and its relevance to an issue at trial. I can tell you in practice, I'm generally not getting that much information. I'm getting vague. It might be text messages. There might be 276 evidence. I'm not really sure. So I'm not even getting that much information. And the court did emphasize, okay, the applications generally, there's discretion, but they should generally be filed before trial on 7 days notice to the Crown. Again, I want to think about this in contrast to the notice requirements in the context of third-party records applications. That's now 60 days notice. And it used to be 14 days. So there was a lot of concern about that 7-day period, about it happening pre-trial. There is a precedent for something akin to this happening, and that has been happening for years. And I sort of cringed a bit when the Supreme Court emphasized the importance of the 7 days notice, in part to allow complainants to retain counsel. That's a lot of time to get a lawyer, get them retained. It's not true. And it really does pose a challenge for complainants to get access to counsel, to exercise their rights to counsel, and particularly to get experienced counsel and counsel of choice, which they're also technically entitled to as well. At this stage 1 part of the process, I don't see this as a significant expansion of complainants' rights. The rights, I think, are actually very limited at this stage. So then moving along to stage 1. So stage 1 is this threshold hearing. The Crown and the defense are there, and the judge ultimately has to decide, is this evidence capable of admission? You'll see I've put out sort of all the possible decisions that could follow from this hearing. And I really only want to include this here to note that, in fact, 3 of these decisions, the first 3, will mean that the complainant never gets any input into the process. They're not involved. It's only if the judge decides that the evidence is capable of admission that you're moving on to a stage 2 hearing where the complainant will get some input into the process. So again, is this a significant expansion of the rights of complainants? Is this an unprecedented expansion? There is no standing for complainants at this stage 1 hearing. Again, unlike the third-party records regime, where they've always had standing at stage 1, and they've always been entitled to have counsel there to represent them and participate in those hearings. The decisions that can be made here are ones that could certainly affect the complainant. If there's a decision that's made that this is not a record and we're not going to stage 2, there's been no input about, but this is why I understand that this affects my privacy rights, or a decision about 276. And there's also, I want to point out, a lot of room for Crown discretion here. They can concede that something's not a record. They don't require complainant input to decide that. They can also concede that evidence is capable of being admitted, moving it along to stage 2. I think because of the busyness of so many of our courts, that is happening because Crowns say, well, we'll just deal with it at stage 2. But if you've had a deficient application at stage 1, it's really hard as complainants counsel or for complainants to move in at stage 2 and make helpful arguments. All right, okay, so moving along to stage 2, this is when complainants do have standing, they get to attend and participate, and this is where ultimately the judges are going to be deciding whether the evidence meets the task for admission. What I've basically included here is what the requirements are from the criminal code. The only thing I want to point out is that the factors that the judges are required to take into account are really familiar factors. They're very similar to what you see in relation to 276 applications. They're also very similar to what we see in third-party records applications. So again, is this a significant expansion of complainants' rights? And this is where I think it's really important to think about some of that judicial discretion that we talked about as well. So the court does say the Crown should typically be providing the application to the complainant to allow for meaningful participation at that hearing. But they did say a judge has discretion to direct that the application not be disclosed or to allow for redactions. And they did not give any parameters around why that should happen. And certainly that is something that we have seen defense counsel requesting, is redactions or that it not go to the complainant. And that, makes it hard to meaningfully participate. And again, when we've had a third-party records regime where there has been access and there haven't been these kinds of arguments about limiting access, that feels like a troubling concern. Similarly, with respect to whether or not the complainant can actually attend the hearing. For what it's worth, normally my clients never have any interest in attending these hearings. They find it really challenging, but that I'm really running short on time. That is something that can be, the trial judge does have the discretion to say you can't do that. Again, third-party records applications, complainants have been able to attend those. So I just want to briefly end by talking about some of the unintended consequences that I think we're seeing as a result of this new regime and the interpretation from JJ. I'm not going to be able to obviously talk about all of them, but this is a really complicated regime. There was a lot of hope that JJ was going to clear it all up. And I think there's ongoing confusion, in part because the incredible judicial discretion that is available in the system. Because we are dealing with a complex regime and a complexity of issues that arise in sexual assault cases, there are more and more pretrial applications that need to be scheduled in cases, often with more than one stage. 11B is a huge problem in these cases. There's also, along with increasing the length of trial, obviously comes increases to the cost of trial. That's a huge access to justice problem for accused persons, particularly in a world where we know legal aid is not available for many. And also for complainants. In Ontario, there is funding available for complainants to get counsel and get representation, but there are real challenges because of the timing associated with this. And then finally, I want to talk about how this new regime that has increased the opportunity for complainant engagement in the criminal justice system is really not something that everyone welcomes. A lot of my clients find that repeated contact, reach out, I'm just another stranger in the system to them. It's hard. It's pulling them back in. It's pulling them back in oftentimes without a lot of information. I don't know what the application is about. They might want to admit other sexual history. I'll know in a couple months. That's really hard. And it's particularly hard for my clients, many of whom come from vulnerable and marginalized backgrounds, whose lives are heavily documented, when they're wondering about what are these records. So the note I want to end on is that while on balance, I think the regime has been really useful to extend protections that are necessary for complainants. I also think it's really confirmed my view that the criminal justice system leaves too many people, both complainants and the accused, feeling like they have no real sense of justice. And I think we really need to lean hard into reimagining alternatives that would better meet those justice needs, including restorative or transformative justice processes.
Thank you very much, Megan. So we have a little bit of time for questions. I think there is a microphone that we can use. Yes, so if you have questions, we're somehow going to get the microphone to you.
You know, talking about complainants' rights and the balancing of rights, would you have any thoughts about this regime extending to non-sexual offenses, like in terms of the constitutionality of that? Like, and this is, you know, with respect to these records that concern the complainant that have some type of privacy interest. Do you see the logic that's been employed in terms of the court saying this is a permissible system? Does that change at all in your view if we were talking about non-sexual offenses? Just out of curiosity.
I'll say two things on that. One is that I think that sexual assault complainants or sexual offense complainants are sort of recognized as being a uniquely traumatized and vulnerable group in a whole series of Supreme Court of Canada cases. And so I'm sure that there are complainants who are similarly traumatized and vulnerable in other areas, but I'm not sure there'd be a lot of appetite to extend it. I just shudder at your question in the sense that I'm already worried about the delay and complexity that's associated with extending this regime as far as it goes to cover sexual offenses, and the idea that every private record in relation to anyone in a criminal trial at all would be subject to this regime is concerning to me for that reason.
Yeah, and I actually think that would be a real extension of the jurisprudence so far. Like, I think you can trace the lineage of this judgment going back to Seaboyer through Mills and then Darragh, and there has been a recognition of the, you know, myths and stereotypes around sexual assault complainants that aren't as live issues in other contexts. So I think that might that is something, it would require, I think, showing a similar kind of thing where people who are really vulnerable and who have been, have received unfair treatment and unfair scrutiny in the past. And then there would sort of need to be a justification for it, I think. And even as I'm saying, I'm like, oh yeah, there are particular classes of, Indigenous women have received lots of really not great treatment in the criminal justice system, both obviously, as we heard this morning in Sharma, when they are accused of offenses, but also when they've been victimized. But I think it would have to be, like, there would need to be sort of a justification for it that was rooted in those types of concerns.
Thank you. Professor Jones, and then we're going to go there. If you can pass the microphone backwards. Thank you.
Yeah, thank you. This question is for Michelle. Recently I was in my 1L crim class. We were talking about substance abuse and perhaps the what can be termed as the liberalization of kind of public policy approaches to drug use. And as you were talking about this new regime, 33.1, it had me thinking about, let's take, for example, the experiment that's currently, going on in British Columbia. And what are some of the impacts of this new kind of statutory approach to drug use? Is that going to, kind of roll back this liberalization that we're seeing? We saw it in, Bill C5, where, Justice, Minister of Justice Lametti is saying, listen, can't, approach this with a, as a criminal issue. It's oftentimes it's a medical issue. I'm wondering, given this new approach, right, are we going to see a walking back of, as I said, this kind of liberalized approach to dealing with, drug abuse in our country?
Thank you. That's a great question. So I asked myself when I was preparing for today whether the legal status of the drug could be used as a proxy for objective foreseeability of risk. Because if it was, it would be problematic. You'd have differential treatment because of the differential legal status of drugs across the country, and I expect there'll be more variation than less as time marches forward. But I went back to Cassier's judgment, and he was very clear in noting that some folks take illicit substances for benign or therapeutic purposes. And though illegal, there's no objective foreseeability of the risk of extreme intoxication, let alone extreme intoxication and harm for others. So I'm not worried about this, but I do flag in my outline that the Crown needs to be attentive to the policy implications of the positions that it takes here, for fear that it could further criminalize people who use drugs in this country.
Please.
Mine's not a question. Does anyone here have a question? I was just going to comment on the comment that was made, or the question about whether this could apply to offenses in addition to sexual assault. One of the things that is in the judgment, but not very much, in paragraphs 1 and 2, the opening statements, and also some reference to Professor Craig's work. The court had a lot of social science material about how difficult it is for sexual assault complainants in these cases. In fact, Professor Craig, in an article called The Unhospitable Court, in a book called Putting Trials on Trials, she actually tracks sexual assault cases, and she has transcript excerpts which were included in the volumes of material that the court had. And the majority doesn't spend a lot of time on it, but I think we have to remember that that's part of the context in which the decision was rendered, how difficult it has been for sexual assault complainants who are just effectively ambushed, with all their text messages and their therapy, not therapy records anymore because we have Mills, but in the past, cross-examination that was unfair, that just as a practitioner, I can tell you doesn't happen in other cases, not to the extent that it happens in these cases. So I think that I would be surprised if this very, very controversial regime would expand beyond sexual assault complainants, but I think there was sufficient evidence before the court to justify it. And the legislation itself, everybody thinks it was a political response to Ghomeshi, but in fact, it was written almost word for word back in 2012 as the gap that was identified in shearing, when there was a diary that was, the defense had in their possession and just brought it out in the middle of cross. Then all of a sudden the court had to deal with, how do we deal with this? And it went up to the court, and they were dealing with the issue of whether, the third-party records regime, which is for records in a third party, could be used as a proxy for private records that are in the hands of the defense. And they said, no, it can't. And then the Standing Senate Committee subsequently drafted this legislation that was probably put on a shelf somewhere and then dusted off in early 2015. So, that's just, like, it's interesting context when you think about sexual offenses.
Thank you very much for this. Are there for the Professor Kerr? Oh, we thought you had a question. Well, any further questions? Well, it's been extended by the grace of Professor Berger, so we have time for your question.
Then. Maybe I'll ask Michelle, you mentioned that you see 33.1, the new one, as sort of the political pathway. And I just want to hear more of your thoughts on that. I take it what you mean is that the government got to look like the government responding to Davio, right? Getting right back in there and sort of recriminalizing something, whatever it could. Although I think there's a real question of, like, what does it mean to markedly depart in the taking of a drug? Because, I mean, isn't this the whole issue in these cases that no one would have expected the reaction these folks had from, you look at the facts of these cases, no one would have expected them to have done what they did. So tell us more about the political path and what you think it's actually going to look like in terms of an offense.
So if you go back to 1995, when Alan Rock was introducing the first 33.1, he was quite insistent that the regime had to result in convictions for the offense charge, for the actus reus committed, even if there was a different mens rea, if mens rea was attached to voluntary intoxication and not the intention of the voluntariness connected to the offense itself. This was a political ambition, and that ambition remains intact with the new 33.1. What I find curious, what I wonder, is why Parliament didn't simultaneously enact an offense provision for criminal intoxication that could operate as a lesser and included offense. Because there is a lot of uncertainty as to the Crown's capacity to establish objective foreseeability of the risk of extreme intoxication and harm for others for the very reasons you're saying. And that has to be established, of course, beyond a reasonable doubt. So one would think that if accountability was really on the mind of Parliament, they would have done both, right? They would have done both to secure those convictions. Even if they couldn't achieve their primary ambition, there would be that secondary ambition achieved. But of course, then you've got the protective purpose. Even if you have a conviction, will it make any difference to what's happening on the ground? Will this deter substance use and intoxicated violence in a meaningful way? And I'm not persuaded it will. Yeah, does that help? Thank you.
Okay, well, yes, one last question. If we could pass the microphone, please. Thank you.
So this is a question for Lisa, and your point about discretion. And it just seems to me, if we think about the Chief Justice and Justice Moldaver having written the majority in JJ, and then them being the two judges who had moved over from Fraser to where they ended up in Sharma, and Sharma being a case where one would have hoped that judicial discretion in sentencing was a good thing that we might want to maintain. I have trouble seeing the consistency of those two positions. And I mean, we're talking about different levels of the criminal justice system, but I'm interested in whether you have any thoughts about lack of consistency
My
there.
only thought is just to acknowledge that I've had the same thought and wondered if I should put something about that in my paper, that there, the way we treat discretion as a matter of sort of curing the ills of legislation under the charter is not consistent across the criminal justice system. So I just agree with your observation, and I'm not sure where to take it from there. No, the consistency is not there.
On this note, please join me in thanking Michelle, Terry, Lisa, and Megan.